to
I think I'll not pass any order of because I think many of them may not be having the
May not
notice
be
also.
Sorry. But item 2 can be disposed of because his prayer is to dispose of the demarcation application.
No, in his absence, it is better. Then
item 3, 4, 5, 6,
anyone present for any item?
6, my lord. Next week, my lord.
6, Mr. Parida.
My lord.
Mr. S.S. Parida for the petitioner. Mr. Bimbisar Das, AGA for the state. Current counsel for the petitioner 6 accommodation. As prayed for. List next week.
My lord.
7,
Anyone present till 20, item 20?
Instruction to appear in number 18.
18, Mr. Mahanti.
Miller. For instruction to appear for the OT LIC in 18.
So you have filed wakalatnama?
No, I've been just instructed.
So you keep a track of it. It will be simply adjourned. It will be simply adjourned. I may request Mr. Das and Mrs. Maharana to wait for some time. I'm waiting. I'll be in the chambers.
Yes.
So if anyone comes, I'll be sitting again.
Yes, ma'am.
And item 18, khali Mr. Mahantinkara item mark karithantu.
Instructions for the to appear for the OP.
Yes. You are Mr. A. Mahanti.
SK na?
SK, I'm sorry.
We all are SK.
SK Mahanti.
You must be knowing about the
Very unfortunate.
people. You are unable to trace the culprit.
Very, very unfortunate. And
Very
after
In the MBS examination, he stood first.
he from beginning he stood first.
no, I know he's from my school.
So the acha.
He's close
He-
to lost his family. also.
He
Very close.
passed out in 88. I passed out in 85. So being otherwise a school topper myself also, I'm aware of who are good students.
Yeah.
And when it's a kind of a view. Mr. Potti, item 20.
I have the opposite party union opinion.
So Swang Prabhu.
My Lordship pardons me. Your Lordship has already covered item 10 and 12, my lord.
It was simply called because of something unforeseen happened, so I had to sit early. So 10 and 12 I'll be taking up. But
Mine.
I'm still, the court is in session.
Mine.
Start your matter is?
16 and 17, my lord.
So Mr. Misra's matter, senior Mr. Misra's matter is 10. Yes, Mr. Misra.
May I please, my lord?
Yes.
Here, the order, my lord, that has been passed, rejecting my prayer for correction of the record on the basis of a will, which is not required to be probated, is under challenge. Now, if your Lordship will see, so far as the will that has been executed is in respect of an area where no probate is required.
Yes.
Settlement authority is not adjudicating the rights of the parties. Settlement authority only records the events on the basis of change that has taken place. Nothing beyond that, your Lordship.
So,
Now, at the-
so here the private opposite parties are those who would be contesting the will or their pro forma.
The Ravindra and Rajendra,
Yes.
my lord, they are, your Lordship, I'll just clarify, my lord.
Or it is a matter of abundant caution, they have been made parties.
It is an abundant caution because, my lord, there is no question of any contest because the probate will not be there. If at all any right anybody wants, he has to go to a forum. civil suit or anything, because there is no requirement of a probate, so far as the will is concerned.
So,
And
so,
my lord,
whenever it is more kind of academic discussion now.
my lord.
Whenever when probate is not required, the letter of administration is issued by the concerned district judge, or it is not required even.
No, it's not required. But probate and letter of administration are two, in the distinction where only there is a right given to administer, but they are only letter of administration, and where it's a case of giving absolute right, it's a case of probate. So therefore, so far as it is not at all required. Suppose hypothetically, I'll just point out one situation. I'll point out one situation.
Suppose Hindu Succession Act.
My lord.
The person, the legatee, will be having the benefit of the will.
Yes.
Suppose Hindu Succession Act says that this property cannot be bequeathed. So then what would happen?
It cannot. Because
In this sense,
property cannot. What happens?
I'm not disagreeing that because of the will he has a right. But suppose it is contested. No one there is to contest. So any administrative action or judicial action is not necessary to give effect to that will.
My only thing I beg to point out to your lordship is even if will is probated also. What the court will decide
then the advantage is that it gets crystallized.
No, only thing is that the court decides whether there has been a valid execution or not.
Absolutely.
Right will come.
Court cannot go into the morality or otherwise, not even legality.
And the other part, your lordship, would be, suppose that person didn't have a right. Even if a will is there, the right is not needed. The court is only testing that whether there has been a valid execution of the will or not. Now here, what has happened, there are two cases have come. There are three other cases also. Now, there were 5 different wills. Those 5 different wills were executed in favor of the present petitioner. And
so he has been preferred by so many persons passing away to be the legatee. He is a preferred legatee of so many persons who have passed away. Anyway,
so my grievance is, my lord,
that is not necessary. But I was just trying to do something, and we have time today. So something curious that struck me, that what would be the fate is not required. So, Mr. Samir Mishra, Senior Counsel, instructed by Mr. J. Pradhan for the petitioner, Mr. Bimbisar Das, AGA for the opposite parties
1, 2, 3.
1, 2, and 3. Hard honored counsel for the petitioner. The petitioner challenge in the writ petition is agreed by the order dated 3rd of September 2024, passed by the Lord and Member Board of Revenue, Odisha. In OSS revision case number, OSS revision case number 293 of 2022, dismissing the revision application, thereby confirming the order dated 26/10/2021, passed by the sub-collector Kaptipada in mutation appeal case number 19 of 2020. Consequently, upholding the order dated 24 July 2020, passed by the Tahsildar Kaptipada in mutation case number 606 of 2019. It is submitted that the Tahsildar rejected the claim of the petitioner to record the case land in the name of the petitioner in the record of right on the basis of a will executed by, all capital WLL, executed by the recorded tenant. The will being dated 22nd January 2020. It is submitted by the Lord Senior Counsel that the will doesn't require any probate as per the prevailing law applicable. In Odisha, which places it is probate is required, Mr. Mishra? Kindly unmute.
My lord, it is Mayurbhanj it is not required. Then some area of Dhenkanal it is not required. But the notified places, ma'am.
For the law,
This is Mayurbhanj,
as per the law, prevailing and applicable.
ma'am.
Issue notice. Para, the learned AGA, upon being served, advance copy appears and waives notice on behalf of opposite parties 1, 2, and 3. Subpara, it issue notice to the opposite parties 4 and 5 by a registered post / speed post with AD. Requisites for issuance of notice will be filed within 5 working days.
Ma'am.
5 working days would be sufficient, Mr. Miss.
Ma'am, more than sufficient.
List after SR.
Item 12 is
The learned AG is requested to assist the court in
My lord,
the question of law.
your lordship is calling it on.
After SR, because so that in fact I asked for that reason that why the notice is to be issued.
That is better, ma'am.
Because but Mr. Mishra says it is due to abundant as a matter of abundant caution he has made them parties.
Right.
They are related to the recorded tenant.
Yes, my lord. So they are in
sons of recorded tenant.
my party is in the court below. So therefore, I have to make them.
But their father is Dinabandhu Panda and the testator is Balumani Panda. Sorry, Bolamani Panda.
Maybe relation because the Tahsildar's order, some reflection is there.
Dinabandhu Panda,
Liberty to
The-
mention for listing before the assigned bench. Yes.
ma'am.
Item 12.
12 is similar, ma'am.
Same.
Same parties almost, ma'am. Same petition.
Mrs. Maharana, you are there in 12.
Yes, ma'am.
Appearance can you are additional standing counsel.
Yes, ma'am.
M.S. Maharana, additional standing counsel. Speak. Opposite party. Say by registered post with speed post. 5 days. 5 working days.
Registered post, ma'am. Registered post 5 days.
Oblique मुझको लिखो.
Ma'am.
It's at your choice. At times
My- my-
speed post is not available also.
My lord, ma'am.
Yes.
Item
Mr.
7.
7 mention करना थी. Any lauded counsel from 1 to 10. 3, please. Mr. A.K. Pandey. A.K. Pandey, item 3. A.K. Pandey for the petitioner. Again. Mr. Bimbisar Das, AGA for the state. Appearance. Yes, Mr. Pandey.
My lord, the petitioner is a widow lady, my lord. So, my lord, there is no other member in the family except that widow, my lords. My lord, a land, right, annexure 1 was recorded in the name of
से कौन आपण परमिशन जो चाहउछन कोन ओएलआर रे
आज्ञा मतलब
शेड्यूल कास्ट शेड्यूल ट्राइब
ना ना
आ परमिशन कोन दरकार
endowments माने कुछ endowment land, let's say, kindly have a glance to annexure 1 for a moment, please, my lord.
पार्टी करचंदी अथॉरिटी को जो जे जो एंडामेंट कहार एंड प्रॉपर्टी सेटा
से कुछ endowment रे endowment commission कहिसन जे property नो, that I am going to show, my lords.
आपण तो पार्टी करना हंदी
Then, for a
अब
moment,
मु कहिबो केन से
my lords, में
वर्तमान तो पार्टी के हेबल एते सो आलोचना होतला वी हैड ए जनरल डिस्कशन
मो
ये ऑब्जेक्ट करूचंती बा करिवे
तहसीलदार is objecting.
तहसीलदार is the authority under the endowments act
The registering authority. Sub-register निमापड़ा.
सी तो आपण आरोप आपण देखिबे दलिल रे भी लिखा हिथिबो प्रोक्त तफसिलभुक्त जमी कोनोसी देवोत्तर संपत्ति नुह जदि सेटा तो आपण डिक्लेरेशन देबे दैट्स अनदर थिंग बट तहसीलदार का रोल कोन अछि
ସେଇଟା तहसीलदार sorry my lord, I'm saying it's sub-register. My lord, I'm for a moment, let's see me kindly hear me. Let's see me kindly.
नहीं आपण ताले देन यू हैव नॉट फॉलोड इट अरे आई एम आपण जो स्टेज रे अछंती मु तार 3-4 स्टेप आगु को अछि बात आपण जदि वर्तमान मु आपण को ऑर्डर कर देबी यू रजिस्टर इट ऑन बेसिस ऑफ व्हाट हु विल कंटेस्ट दैट आई एम आस्किंग यू जदि आपण पूछंती देवोत्तर बिकॉज़ आई आस्क्ड यू व्हाई इट इज ए ओएलआर ले सेम इंस्ट्रक्शन नेबे
My lords.
but you are saying that it is a devottara property so that is how the sub register is not allowing So because you have to make that declaration as per the Registration Act that it is not a Devottara property.
That I'm going to show, my lords.
Sorry?
That
Subuni,
is going
subuni.
to show, my lords.
ଆପଣ ଯେତେବେଳେ bow down ମାନେ ନଇଁ ଯାଉଛନ୍ତି ଆପଣଙ୍କର ସାଉଣ୍ଡ ପଳଉଛି ବଡ ମିଷ୍ଟର ବେହେରାଙ୍କୁ ଫଲୋ କରୁଛନ୍ତି ସେ ମାନେ ଆପଣଙ୍କର ଯୋଉ ଏଇଟା ଉପରେ ରଖିକି ଏଇଠି କହିବେ
ଗୋଟେ ମିନିଟ୍ ଖାଲି ଦେଖନ୍ତୁ ଆପଣ ଆନେକ୍ସର 1 ଟା
ନାଇଁ ଆଇ ଆର୍ ନଟ୍ ଦେୟାର ଆପଣ ଯୋଉ ଯାହାକୁ ପାର୍ଟି କରିନାହାନ୍ତି ମୁଁ ସେଇଥିପାଇଁ ନହେଲେ ମୁଁ ନୋଟିସ ଇସ୍ୟୁ ଏବେ କରିବି ସାଙ୍ଗେ ସାଙ୍ଗେ
notice
ବଟ୍ ଆପଣ ଯଦି ପ୍ରପର ପାର୍ଟିଙ୍କୁ କରିବେନି there is no point in issuing notice.
may I say, my lord?
You see, Mr. Pandey,
My lord.
what Mr. Das will say, it's often instruction from the sub-register that since this property is a Devottara property, so he cannot register because you have to give a declaration as such in that sale deed.
My lords,
And suppose thinking further, I would step back. Suppose you can give a declaration also that though it is a Devottara property, I have got the appropriate permission from so and so authority by case number by
my humble submission is, my lord, no permission is required. What I humbly say, my lord, let's say, I'll have a glance to annexure 1 for a moment, my lords. Patita Pavana Deva, Nichoga, Swami, Indumati Vatta Mahadi, the present petitioner, my lord. Once I approached the sub-register for selling of the land, he denied by saying that it is a property of endowment in nature. Thereafter, I filed a case by the annexure 2.
ଆପଣ ତହସିଲଦାରଙ୍କୁ କାହିଁ ଆପ୍ରୋଚ୍ କଲେ ମୁଁ ସେଟା
Sorry, madam, again, I'm sorry.
ସବ୍ ରେଜିଷ୍ଟର ଆଚ୍ଛା ସରି yes please carry on ଆପଣ ଆଜି ସବ୍ ରେଜିଷ୍ଟରକୁ ତହସିଲଦାର କହୁଛନ୍ତି ଆଉ ଫାଇନ୍ ଠିକ ଅଛି
Sorry, ma'am. I filed a OA number 46 of 2000 before the endowment commissioner endowment powers. The order of the commissioner endowment, your lordship will found at
page 14.
page 14. Where is the bottom, my lord, say it is not a property belongs to my lord's endowment and there is no objection is required for registering the same. By virtue of such order, I have already sold a portion of land, my lords, by the annexure 3.
He has not dealt with that. What page 15 ପଢନ୍ତୁ
My lords.
where he has dealt with ପତ୍ତାବନ ଜୀଉ ଦେବ and
There is no observation either in
ସେ just
section 9.
ଆପଣ ମାଇକ୍ରୋଫୋନ ଟା ଆଡଜଷ୍ଟ କରନ୍ତୁ ଆପଣ ତା ତଳକୁ ଏମିତି ରଖିବେ ନା ଏମିତି bend it completely ତଳକୁ ପୁରା କରିଦିଅନ୍ତୁ
No provision either section 19 or 19A for giving permission or no objection.
slowly ପଢିବେ so that you will get it what we are discussing ହଁ
I will read it from the beginning, my lords.
ନା ଆପଣ ମାନେ ତରବର ହେଇ ପଢନ୍ତୁନି ସ୍ଲୋଲି
ଫାଷ୍ଟ ପାରାରୁ ପଢିଲେ ବି ସେ ପାଇବେ
First paragraph ପଢି ଦଉଛି.
ଫାଷ୍ଟ ପାରାରୁ ପଢନ୍ତୁ ବେଟର
This is an application purported to be under section 19A of the OHRE Act, praying for granting no objection certificate for sale of some immovable properties on the allegation that although originally the properties belongs to public deity, the petitioner acquired the same in an execution sale, whereafter it has become her personal properties having lost the character of public religious and endowment.
so that is your own case before the endowment commissioner
My lords,
that you have purchased a property of a public religious endowment
my lords,
and that is how it has lost its character.
my lords.
So then how he will then ପଢନ୍ତୁ further ପଢନ୍ତୁ
Section 19A only provides for an embargo on the power of the registering authority to register a deed of transfer of immovable properties belongs to a public religious institution without the order of the sanction or no objection from the commissioner of endowments. Permission for sale of endowment properties, if any, is to be obtained in according with the provisions under section 19 of the Act. There is no provision either under section 19 or 19A for giving permission or no objection by the commissioner of endowments for transfer of the immovable property not belong to a public religious institution. The claim of the petitioner being that the properties in question are her personal properties and do not belong to the deity in question. There is no scope to pass an order for permission or no objection for sale. The petition is not maintainable and therefore rejected. The petitioner is at liberty to satisfy the registration authority with the order of any competent court that the property are her personal properties,
This order has been challenged.
not challenged.
It's not challenged.
But by
So,
virtue of that
this order I cannot set aside because the last conclusion para is contrary to the first para.
my lords, my lords.
So your case before the endowment commissioner is that it is a public religious endowment.
my lords,
Because I purchased, it has become lost its character,
My
which is
lords.
that
My
concept is not there.
my lords.
That concept of a public religious endowment. Since we have time, I am not. I am suspending some time. There is no concept of the public endowment, public religious endowment losing its character by sale to a private person because the sale is itself prohibited
my lords,
without the permission.
my lords.
So now you have two scenarios. While purchasing the property, you had the permission under 19 capital A.
My lords,
It has been registered. So whether it is a transferable right, as mentioned in that sale deed, that is another thing.
my lords.
I think it would be a transferable right. That is my humble understanding. But what you are showing is completely against you.
But my lord, by virtue of that order,
So the last concluding paragraph is contrary to the earlier two paragraphs.
definitely.
So you think about what to do.
My lords, what I humbly submit. Thereafter, the authority, the same registering authority, allowed me to sell 20 decimile of land out of the properties.
The illegality cannot be perpetuated because he did not because you see the commissioner in the rank of he's a senior highest judicial officer. First paragraph he records that the property is a public religious endowment, and in the conclusion paragraph he said it's a personal property. Then what he was deciding then, or what he was asked to decide? Maybe you added to the confusion, but he should have a consistent view. And interestingly, the ROR is still in the name of Patita Pavan Jiv Debo Vijay.
My lords, but the same registering authority, my lord, allowed the petitioner
That
to
is
sell some portion of land.
So
By
registering
virtue of the
authority committing a mistake cannot be a binding precedent for the High Court. But you can ask the same registering authority, he can commit a mistake.
From the beginning, my lord, I'm submitting that it's a petition as a mercy petition before lordship
No.
rather than a under law, because my lord, there is no other member.
Mr. Pandey, you have been representing both sides. DT is a perpetual minor. That is the obligation of the court.
But my lord, when some
Why? Then everywhere there is property, then why the endowment is under the law department, under the government is the parents'
My
patria?
lords, the endowment commissioner himself stated that no objection is required for restoring the land. My
So
humble
that order, you see, if I go, by this time, at least you must be confident that I can deal it in merits. It is up to you. That order, 19A order, is on the face of it is contrary to the past two paragraphs. Then you see even assuming that whatever you stated he has quoted, that is again wrong. First paragraph here states that you say it is a public religious endowment because you have purchased, it has lost its character. Concluding paragraph he says that it's your personal property because as per your statement. Your statement is not that. So what can be done? So I can deal it with on merit. It's up to you. जो बुढ़ी लोकंकर केही नाहंती से ठाकुरଙ୍କ प्रॉपर्टी बिकी परिबेनी. You saw that law. Some Supreme Court decision. सेटा मोर पर्सनल सुनतो इतरे मोर व्यक्तिगत तो ये नुह ना कि मिस्टर पांडे कि मिस्टर दासंगर नुह. बुढ़ी लोक केही नाहंती से ठाकुरଙ୍କ प्रॉपर्टी को बिकी देबे.
20 डिस्प्लेटा बिकिया देइछन सेही सेम रेस्टोरेंट
से भूलटा से बारंबार करि परिबे.
तेणु आ गोटे 28 डिस्प्लेटा बिकी देले बंची जाता सेटा होछ कथा.
नहीं बंचिबा पई ठाकुरଙ୍କ प्रॉपर्टी बिकी बंचिबे. दैट्स नॉट द फंडामेंटल राइट टू सेल प्रॉपर्टी डजंट एक्सटेंड टू सेलिंग एंडामेंट प्रॉपर्टी. दैट आई कैन ऑब्जर्व आल्सो. On your own statement he records. You see how माने मु जाननी जदि if that is a correct certified copy सेटा ना typed copy. Certified copy then it's a माने palpably wrong order. Even you do not state that it is your property. Yes. You say that I have purchased the endowment property and this happens.
My lords.
And Mr. Pandey, if you have purchased that, kindly mark again paragraph 1.
My lords.
What the innocent old lady has done or doing. पेज को author जान. Page 14 को जान तो.
My lords.
The petitioner acquired the same in an execution sale. Where are the details? The innocent old lady acquired that with a execution sale. Where are the details? What better document you can have of right title interest than the execution sale if you have purchased?
My lords.
So it must have been auctioned. If it is execution sale, there must be order.
Before, my lord,
So being old and being innocent are completely different also.
my lords.
Somebody gave old and she has to sell DT property.
My lords.
If you have any authority on that, then you so that I can at best I'll feel that I can consider it.
My lords,
Upon it, merit we have enough discussion. Since I am only having a, so you have your chance to argue.
but my lord, my petition filed before the Independent Commission was something else. I've annexed it. The present petition is filed for no objection certificate.
Who decided? Who
Page
pays
10. Page 10. That the present petition is filed, obtain no objection.
Where you have mentioned in your execution case number 3714 of 1938-39, decree holder Binod Bihari Parida, Sudarshan Parida, minor.
My lords. They were both represented through uncle, guardian Binod Bihari Parida, among Parida village so and so. Purigat got the
Order 21 Rule 94 CPC against Pattabhavan Dev,
My lords,
represented to Marfatdar Jagabandhu Rayat Singh.
my lords.
So that opens a kind of a situation where it is more, the pitch is more clear now.
My lords.
So you do not know anything.
Got the order of certificate of sale, land under 21 of Rule 20.
Upon that site kain koleni?
Against
Seita upon site kain koleni? Upon say order 2000 re 25 ବର୍ଷ ହେଲା challenge ବି କରିନାହାନ୍ତି.
ସେଟା କରନି old lady. କେହି ନାହିଁ ତାର ଆଜ୍ଞା.
ସିଏ ସେତେବେଳେ ତାଙ୍କର ସେତେବେଳେ ପ୍ଲି ନଥିଲା ବୟସ ହେଇଗଲାଣି ବୋଲି. ଆପଣ ଯଦି 25 ବର୍ଷ ତଳେ କରିଥାନ୍ତେ
Represented Marfatdar Jagabandhu Rayat Singh of village so and so.
ବୟସ ଲେଖିନାହାନ୍ତି.
Time substituted by minor so and so who represented.
ଆମର ପାଟ ମହାଦେଇ ଯୋଉ
ଆଜ୍ଞା.
ସିଏ ତାଙ୍କ ବୟସ କେତେ ହେଇଥିଲା ସେତେବେଳେ ଲେଖିନାହାନ୍ତି.
ବାସ୍ ଇଏ କଲା ବେଳେ ଟ୍ରାଏଲ କୋର୍ଟ ଓକିଲ ଆଜ୍ଞା କଣ କରିଥିଲେ?
ନାଇଁ ଟ୍ରାଏଲ କୋର୍ଟକୁ ସେମିତି କହିବେନି. They are better stuff. They are at the interface. ଏମିତି କହିଦେଲେ କେମିତି ହବ?
Sorry my lord, sorry.
ସେଇଟା କୁହନ୍ତୁନି. Anyway ଯାହା ହେଇଛି ସେ ତାଙ୍କ ବୟସ ଜଣେ. But without mentioning the age, the affidavit format is not satisfied also.
My lords.
Anyway, that's besides the issue.
That in pursuance of order of Sarsani case number so and so, auction has been conducted.
Shuntu, there is a possibility. There is a possibility that like I am asking you about these things, you may get a chance not to address those things. So you wait for that chance. But I will ask these questions. Right now I can deal with it.
এই পিটিশনটাକୁ ଦେଖିଲେ ଜଣା ପଡୁଛି ଯେ ପ୍ରପର୍ଟିଟା ଅକ୍ସନ ହେଇକି ପବ୍ଲିକ ହେଇକି ସେଲ୍ ହେଇଛି ବୋଲି. ପାରାଗ୍ରାଫ 3 ଟାକୁ ଦେଖନ୍ତୁ.
ଆପଣଙ୍କର ଏଣ୍ଡାମେଣ୍ଟ ପ୍ରପର୍ଟି ଅକ୍ସନ ରେ ସେଲ୍ ହେଇପାରିବନି unless he is the defendant. Marfatdar
My lords.
cannot sell.
এটা কোন Sarsani case number so and so. Dated 10 to the ମୁଁ କହୁଥିଲି ଗୋଟେ ପର୍ସନ ଲ୍ୟାଣ୍ଡ ଯେହେତୁ ବିକ୍ରି ହେଇଛି ସେଇଟାକୁ କନସିଡରେସନ ବିଚାର କରିପାରନ୍ତି ବୋଲି କହିଛନ୍ତି.
ସେଇଟା ଆପଣ ଦେଖି ମୁଁ ତ ପ୍ରଥମରୁ କହୁଛି ଯେ if there is an authority on this either of High Court or Supreme Court ତାହେଲେ ଦେଖାନ୍ତୁ. And ସେଥିପାଇଁ ମୁଁ ଆପଣଙ୍କୁ case 2
My lord.
Mr. S. Raut for the petitioner, Mr. Bimbisar Das AGA for the, you are Mr. Raut?
Yes, my lord.
Bimbisar Das AGA for the state. Yes.
My lord, the impugned application is at annexure 2, which is pending before the opposite party number 2. Opposite party Tahsildar Tangi Chaudhar, a direction may be given to dispose it for a demarcate the land, my lord.
Let him obtain instruction.
My lord.
Yes.
Publish.
The hard learned counsel for the petitioner. The petitioner raises a limited grievance regarding non-disposal of the demarcation application dated 16.05.2023. Vide annexure 2 to the writ petition. The learned AGA shall obtain instructions in the matter. List after 2 weeks. से अपन को नोटिस देला पर कि जानती नहीं एक्चुअली डिमार्केशन में प्रॉब्लम होची सेटा आपनको वारंट तो नुह सो द पर्सन विल नॉट कम आपनकर जे चौहदरे जे अछंती दे इफ दे डोंट कोऑपरेट इट कैन नॉट बी डन they have to be present and they might be having some dispute civil dispute with you so demarcation se kari paribeni seta maybe could be देखो yes next author serial डाकत दो डाकले ना author तीन गला चार डाकत
item 4, 5, 7, 8. 8 is busy.
yes Mr Patnaik is upon 7 so yes 8 yes Mr Subhasis Patnaik Mr Patnaik unmute yourself you are वॉल्यूम चेक कर आपनकर जो मीटिंग को जाई कि गोटे अछि आपनकर इनपुट वॉल्यूम ताको 100% कर दियंतु एटा त हमर सी ताक आपनकर माइक्रोफोन इनपुट देखंतु or else you rejoin आपण आउथरे बाहर के आउथरे जॉइन कर दियंतु हमर स्पीकर ठीक अछि बसन next 8 pass over Mr Das he has some technical difficulty yes next dakontu
9,
pass over we have a very brief time so ठीक अछि pass over 9 तापर डाकंतु 9 pass over
11,
8 pass over 9 pass over item 11 डाकंतु next
item 13,
Yes,
legal lordship. Minor kindly adjourn this matter.
आपण को नाटा Miss Ghosh
Second.
Miss S Ghosh for the petitioner is Maharana for the state opposite party the learned counsel for the petitioner seeks accommodation next week
2 weeks after.
आज spread for list after 2 weeks
14,
Operational.
yes please
On behalf of Mr. M.S.Sahoo, I pray for 1 week after.
your name sir
Bablu Barik.
Mr. B. Barik on behalf of G.N. Sahoo for the petitioner. Yes, Maharana, AC for the state. Learned counsel for the petitioner seeks accommodation. How much time?
1 week after. 1 week.
List after a week.
Bablu.
Yes, Mr. Patnaik, can you hear?
15,
Mr. Subhasis Patnaik? And next account.
15,
Next.
16,
So Swayam Prabhu Jena for the petitioner. Mr. Miss Maharana, Sarita Maharana, AC for the state. Yes, Mr. Jena.
My lord, the petitioner's prayer is to count his past service rendered as my lord junior assistant in Utkal Cooperative Banking Society from 1980 to 1997. He was initially appointed as junior assistant in the banking society, my lord. While working as such, an advertisement was published where the criteria
Here, have they considered this and passed any order?
they have not yet considered my.
No, did you ask them to consider?
My lord, I have represented under Annexure 7 because in
Because in these kind of matters, once you do not allow them to consider, what happens? They straight away come to the court and say that you are not entitled.
My lord, I pray that a direction may be issued to consider my representation under Annexure 7, taking into account Annexure 4 and 5, my lord.
No, they may not, that you can challenge.
My lord.
But who is to consider?
To consider registrar of the cooperative society opposite part number 3, my lord.
When did you retire?
My lord, I retired, my lord.
30/11/2018.
2018, my lord.
Mrs. Maharana, so what to do?
My lordship, direction may be given to consider.
First you but you make a representation
Yes.
with proper materials and
My
particulars.
lord, I will fail.
Where in your representation you have stated that it was pensionable service?
My lord,
That what
I have mentioned that since similar footing, a person has already got.
Everybody has foot almost identical. If I can say so in a lighter vein. But does that make a service pensionable? And if the pensionable, then there is some concept of contribution also.
My lord, I have decided to forgo the CPF benefit, my lord. As per the finance department circular, I have quoted, my lord.
So all these things you have to make a detailed representation.
Yes, my lord, because in the meantime
ठीक
also.
है जी, Mr. Swam, लिखिए appearance section. Hard learned counsel for the petitioner. It is submitted by the learned counsel for the petitioner that for the present the petitioner raises a limited grievance. That is, the opposite party number 3 registered cooperative societies to consider his representation and dispose of the same in accordance with law. The learned AAC in response submits that any representation that is made shall be considered in accordance with law by the appropriate authority and decision shall be taken thereof. For having had learned counsel for the petitioner and the learned AAC for the state without issuing notice to the opposite parties, in view of the limited nature of prayer made by the petitioner, the writ petition stands disposed of, observing that the petitioner shall approach the OP number 3 along with copies of the the petitioner shall approach the OP number 3 with certified copy of this order along with copy of the representation already and all other documents sought to be relied upon by the petitioner for redressal of his grievances. The authorities shall do well to consider the same in accordance with law and take a decision within a period of 3 months from the date of communication of the certified copy of this order along with other documents. The decision so rendered by the authorities shall be communicated to the petitioner within 2 weeks. The authority, if it so feels, can ask the petitioner to provide any other such information / documents for adjudication of his grievance. For redressal of his grievance, not adjudication, for redressal of his grievance. It is clarified that this court has not expressed any opinion regarding the merits of the claim of the petitioner or contentions of any of the parties to the petition. Yes.
That's 17. 17 also same.
Same cooperative.
Yes, madam.
Same opposite party.
Madam.
Same order.
Right.
Yes. So petitioner ऊपर लिखी ले, the petitioner who has stated to have retired from service while working as
My lord, in
16 रे कौन?
and in 16 he is a retired sub assistant auditor general of cooperative society, my lord.
Would lecture दी?
My lord, in page 1, my lord.
अच्छा, page 1 देखिए लिखी हुई हो. 17 ने भी lecture दी?
Yes, my lord.
Oh,
In
ठीक.
page 1, retired auditor of cooperative society, my lord.
All right. That would be reflected. Yes, next.
Obliged.
Item 18. Arjun.
Petitioner have applied to disburse the matured amount of the
Repeat,
LIC
Arjun.
policy.
18. इसके मान से
हाँ, Mr. S.K. Mohanty, who usually appears for LIC, he sought for an adjournment.
Right.
So he says that he has instructions to your name, sir?
S.R. Tripathi.
Mr. S.R. Tripathi for the petitioner, Mr. S.K. Mahanti for the opposite party. The learned counsel, Mr. Mahanti, submits that he has instructions to appear on behalf of the opposite parties. The learned counsel for the petitioner shall serve an extra copy on the learned counsel, Mr. Mahanti. As undertaken by the learned counsel, Mr. Mahanti, he shall file Wakalatnama on behalf of the opposite parties by the next date. List after 2 weeks.
19.
Mr. Behra. Mr. Joydev Behra for the petitioner. Mrs. Maharana AC for the state. Yes, Mr. Behra.
Last occasion,
Copy देना
Copy देखिए but हम लोग को instruction किसी आसने उठ के time दर करो.
limited grievance, my lord. My lord, can you see the page 11, my lord? To accept the premium amount.
See, positive instruction nebe. So I have clarified this that the read court extend the time. Because if you observe that in order, the last line, the authority simply, OLR authority simply says that since he has not deposited the amount, it is rejected. But it's a valuable right.
କିଛି ଆଜ୍ଞା ସେମିତି ଗୋଟେ stipulated time ଦେଲେନି କି ଆମକୁ କିଛି notice ବି ହେଇନି ଆଜ୍ଞା.
I will take the instruction.
But seat part ଟା ମୁଁ examine କରିନି. ଆପଣଙ୍କର ସେ ସବୁ ଜିନିଷ ଆମେ ତର୍ଜମା କରିବା ନା ଆପଣଙ୍କର କେମିତି ହେଇଯିବ accept ହେଇଯିବ ସେଟା ବୁଝିବ.
କହୁଛି ଆଜ୍ଞା
ହଁ ବାସ୍.
more limited.
Yes. The learned counsel for the petitioner refers to the order dated 29th January 2025. Particularly, paragraph 4. Stop. The learned AC in response submits that she requires further time to obtain instructions. As prayed for, list. How much?
Next week.
List next week.
Yes.
Jodi bench hey paribo tale se positive nebe kahichante apanku apon tanku tiki chance diyon apon tanku to paisa seti deleni apon fees nele
ନାଇଁ ମତେ ଅବଶ୍ୟ କିଛି ଦେଇନାହାନ୍ତି.
ଠିକ ଅଛି ଆପଣ ପ୍ରୋ ବନ ଠିକ.
Item 20.
Petitioner none, Mr. Manoj Kumar Patti, Senior Panel Counsel for the Union of India. अच्छा रेलवे ପାଇଁ କି appear କରୁଛନ୍ତି?
Sir, all the
ପୁରାଟା.
Aye.
So for the opposite parties. None appears for the petitioner to grant further opportunity. List next week. Pass over daki diyantu.
Item 1.
My lord, may I pray, my lord?
Yes, please.
See, my lord. My lord.
Mr. Diptendu Sundar Rai, ds.s.rai for the. ଆପଣ ସୁନ୍ଦର ରାୟଟା ଅଲଗା ଲେଖୁଛନ୍ତି?
ଆଜ୍ଞା ଅଲଗା ଦୀପ୍ତେନ୍ଦୁ ସୁନ୍ଦର
ଅଲଗା କରୁଛନ୍ତି ଠିକ ଅଛି.
ଆଜ୍ଞା.
Mr. D.S. Rai for the petitioner, Mr. Bimbisar Das AGA for the state. Yes.
My lord, I pray, my lord, next week, my lord.
The learned counsel for the petitioner seeks accommodation as prayed for next week.
Next week, my lord.
Next week. List next week.
Obliged, my lord.
Yes.
Item 4.
Petitioner none, Mr. Bimbisar Das AGA for the state. None appears for the petitioner, though the matter is called again. The matter is called twice over. I'm thrice na 4 times kar delani. ठीक है. Twice over to grant further opportunity. List next week. ठीक है. Hype same order. Mr. Das petitioner none. Mr. Bimbisar Das AGA for the state. None appears, though the matter is called twice over to grant further opportunity. List next week.
7.
7 kyote kahile to na. Madam, you are there for the 7.
Mr.
7.
Yes, sir.
Yes. You are Kaushal.
Yes.
Kaushal, what do you want?
Kaushal is absent, ill. So this matter may kindly be taken up 1 week later.
What's your name?
Anushya Kara.
Ms. A. Kora for the petitioner, Mr. Bimbisar Das AGA for the state. 1 week after you were saying, the learned counsel for the petitioner seeks accommodation as prayed for, list after a week. Yes, Mr. Patnaik.
item 8,
No, still the audio is not there. Mr. Subhasis Patnaik for the state, Mr. Bimbisar Das, AGA for the state. Due to some technical glitches, the learned counsel, though present in VC in virtual mode, is unable to address the matter. Stands adjourned next week.
9,
May I please?
Yes.
Get the petitioner before Lordship.
Mr. You are Mr. Jena, Mr. KK Jena for the petitioner, Mr. Bimbisar Das AGA for the state. Yes.
What happened in this case, my lords? The petitioners, in the adjacent plot owner of the property under annexure 1 is the my property, my lords. But the khata number 245 and area plot number 1608.
Let him obtain instruction.
I will give it, madam.
Do you have any case pending? Like revision petition?
No, my lords.
How do you stake a claim on a government property? Suppose you do not file a case for correction of ROR, this may be consequential. I understand your grievance that they are constructing on your land, but they say that it is a government property.
It's a,
so you have to address the main issue.
If the government property, my lords, it is recorded in
I have already passed the order. So Jena, I have already passed the order. I have directed, but I want the instruction from you, response from you. That suppose I will simply say that you don't construct. How does it help you? Because they say that we are constructing on a government land. You should ask these questions to when you are receiving the brief. You should ask these questions so that you can make an effective presentation.
Admittedly recorded as a Rokhit matters, but that land should be protected by the state.
Rokhit Khata is government. They are the owner. Rokhit English reserve. So reserve makes them a better understanding of
that reserve land matters. We have to forcefully acquiring. Making a Jagya Mandapa matters. Making a Jagya Mandapa.
Oh, Jagya Mandapa. Private people have encroached.
Private people are encroaching.
Sir, you are saying that I can take up any matter. This is OPLE. Proceeding Hichi.
No proceeding initiated by the state authority.
When did you make the authority aware?
Yes, I have given all through I given the representation matters. And one
appearance like
107
Mr. KK Jena for the petitioner, Mr. Bimbisar Das AGA for the state, hard learned counsel for the petitioner. The learned counsel for the petitioner submits that he espouses the cause of the public at large, in a sense, as the government land has been encroached by certain people for construction of their own for their utilization and their which is being utilized for construction of certain buildings, certain structure. Again, PIL bench actually.
No.
No, କେମିତି ଆପଣ
ଆପଣଙ୍କ ସାଇଡ୍ ପ୍ରପର୍ଟି ଆପଣଙ୍କର ନୁହଁ ଆପଣ କହୁଛନ୍ତି ଏଟା ମୁଁ ପ୍ରଥମେ ଭାବିଲି ଯେ ଆପଣ ନିଜ ପ୍ରପର୍ଟି ପାଇଁ ଆସିଛନ୍ତି
but I am agreed my lords that property I have used
submits that in all fairness the matter should be listed before the PIL bench.
No matter
registry to do the needful.
I will satisfy my
learned AGA are city satisfied the better satisfaction habo city adhika balo the learned AGA shall obtain instruction. This much I will at least he will obtain instruction.
Okay.
11,
item
5 ଗୋଟେ ସେକେଣ୍ଡ ଆମର ଏଟା 5th time around so ତେଣୁ ଆପଣ ଟିକେ ରୁହନ୍ତୁ 11 petitioner none Miss Maharana Ms. Sarita Maharana for the state. The learned counsel for the petitioner 6 non appears for the petitioner when the matter is called. Non appears for the petitioner though the matter is called twice over. List next week. Next please. How pass over kete rahela? Kanungo, Mr. Potti was here. So but he has left, I think. The upon pai be abhitre because our matter nahi. There is only one matter left.
15.
No, it has been adjourned, simply adjourned. Appearance ta take kar debe. Kudire, Mr. No, I understand. The bench was preponed. That is how I have called every matter 5 times. Mr. Agosti Kanungo kar debe for the petitioner, Mr. M.K. Potti, Senior Panel Counsel for the state, for the union. For the opposite party, see, railway pe appear korchunti. Next week korte untu. Non-appearance ta korlo kati debe. 20.
15.
20 बोधे आपण नहीं नांती आप आपण पूर्व हां ठीक अछि हम कहि देबे ठीक है मिस्टर पटनायक 15
notice is required to go because other connected cases notice is there.
RSCP Mr. Rabindra Kumar R.K. Patnaik for the petitioner, Ms. S. Maharana AC for the state, Alternate counsel for the petitioner. The petitioner is agreed by the order of rejection dated 22nd March 2024, passed by the opposite party number 1, rejecting the prayer of the petitioner, rejecting the claim of the petitioner for grant of grade pay, grant of RSCP and consequential grade pay at a higher rate or lower rate, at a higher rate than he has been receiving. It is submitted that the rejection of the petitioner's claim for RSCP and consequential grade pay is contrary to law and the material on record. Issue notice. The learned ASC upon advance copy served appears on behalf of the opposite parties 1 to 4. Sudhir Patra kode gale asinanti aji. You will inform the learned Mr. Sudhir Patra, learned counsel, standing counsel for the OP number 5, Accountant General into bracket A and E, appears and waives notice. Waives notice. Appears and waives notice. The learned AC upon advance copy being served appears and waives notice on behalf of OP number 1 to 4. Then Sudhir Patra, same, appears and 5. The learned counsel for the petitioner shall serve Ms. Maharana. How many extra copies?
One extra copy.
Shall serve 1 extra copy on the learned AC and 1 extra copy on the learned counsel Mr. Patra for OP5. In response, the learned counsel appearing for the opposite parties seek 4 weeks time to file their response. As prayed for, 4 weeks time granted for filing of counter affidavit, which shall be filed upon serving copy on the learned counsel for the petitioner. The learned counsel for the petitioner shall have the petitioner shall have, not counsel, the petitioner shall have liberty to file rejoinder. List after pleadings are complete, liberty to mention for listing before the assigned bench. Yes.
Item 5.
Am I audible now?
Yes. You are now audible. Now you come through mobile, so your audio was not working out. Yes. Item 8.
Item number 8 is
Mr. Das. Mr. Subhasis Patnaik for the petition. Item 8. Mr. Bimbisar Das AGA for the opposite party, state opposite party.
Here what has happened, I am the
Notice
patient
1,
petitioner.
TO2, 3. Yes.
Here what has happened, one revision case was filed by me. In spite of 2 cell deeds, my name was not recorded. That is why I filed a revision case before the commissioner settlement for recording of my name. My advocate's father was ill and he was hospitalized. Therefore, he couldn't appear on the date. That is, it was dismissed for default and disposed of. That is why I am a comma before Lordship. Your Lordship, kindly come to page number 17.
There is no provision for filing
No,
restoration.
I have checked up. No, I have checked up.
CPC not applicable.
But the procedure is applicable, but there is no specific provision for restoration application to be filed there. I have checked up.
No.
That is why people Lordship,
Because that
if you
is a
Lordship secretary remand the matter, then it can
Service
be had on
settlements-
merit. Only one opportunity is needed. Only that much only.
But for that you have to take notice to 16 people. But they are on record. They are before that.
I am not getting pray
Why?
for merit on hearing. Don't I need any hearing on merit? I only pray that.
I
that
understand.
matter
I
will
understand. No, please. I am on a different point altogether. Suppose to remand it, I now have to issue notice to OP number 3 to 16 because a substantial right has accrued because they are the appearing parties there.
But
They are already on record there and their counsel is present. So if you file a recall petition, you can withdraw this.
No. What I pray, my lords, then I will take notice. If your lordship will permit me, I will take note to them.
Wow.
It will take some time, but I'll take notice.
Why should you require permission? I have to issue notice. That
Yes,
is,
yes.
otherwise,
I'm
hearing
sorry,
how can I in a and when you say that they are the
I'll
contesting
take
parties.
I'll take notice.
So then now the next point is very important. Now suppose they appear per 16 people, they are already appearing there before the authority. So there comes the difference. High Court has to issue notice to them. In that matter, they are already recorded and appearing through their lawyer there before the authority. So that is how the recall petition will help you.
I pray I will take notice. If lordship will direct, I will take
counsel for the petitioner.
Special messenger, I will take notice to special messenger, and lordship fix a short date so that it will
without the detailed address, it is not possible. Upon speed post nahi jante, but upon address dehi nahanti.
On speed post, I will take notice to at page number 3. I have given address.
It is submitted by it is submitted that the petitioner is agreed by the order dated. Dismissal order 2 page.
Last page 17, page now 17, 15/4/24.
15/4 na 5/4?
5/4. Copy is to side 5/4.
By the order dated 5th of April 2024, passed by the additional commissioner, additional revisional court, BBSR, Bhubaneswar, additional revisional court number 2, Bhubaneswar, in a proceeding initiated by the petitioner
under section 15B.
Under section 15B of the
OSS Act.
Odisha Survey Settlement Act, 1958. It is submitted that the petitioner, though was represented due to the father of the counsel for the petitioner falling ill, absence was marked and the petition was dismissed. So you sentence likely the counsel falling ill, the counsel could not attend. The counsel could not attend, and the petition was dismissed. It is submitted that the petitioner will be satisfied if the matter is remanded to the authority for hearing on merit. Even I can do that now, but what would happen? Just imagine. 16 people will come or 13 people will come and say that we are not heard. It becomes
they can keep it open for them. They can recall that order. If they are agreed, they can recall this order.
You see, you are not filing saying that you are not filing that saying that you don't have a right of to pray for recall. That I was
No,
asking.
you have to keep
Now
it
you are
open
saying
for
that they
the-
can
if
file
they
for
agree
recall.
by this order, they
If you
can seek
notice,
clarification or
Learned
recall of that order.
AGA, the Learned AGA appears on behalf of the opposite parties. One and 1 to 3.
आगे 1, 2.
1, 2, and 3.
1 to 3.
Also notice to opposite parties 4 to 16 by registered post / speed post with AD. Early returnable date. List after SR. Service return. Liberty to mention for listing before the assigned bench. Yes.
Item 5.
Item 5, I am challenging the.
Mr. N.P. Patra. N.P. Patra for the petitioner.
I am
Mr. Mr. Das, AGA for the state. Yes, Mr. Patra.
I am challenging the order under Annex 5, and 2 cases has been the division bench has passed order.
Yanas, speak to the microphone, please. Kindly speak to the microphone. What you are filing, that is not on record.
This honorable.
Kindly just address. Come here and address.
This honorable court in another 2 cases, similar lease case, it has been passed by the division bench. Issue the honorable judgment. The order.
Well, more the jurisdiction in apna ya khuchandi.
Seta OSS case re boli.
Seta apna seta tamu arjun kodu che apna dekhantu book karantu. How can mu to seta mo kamo bi no seta registry dekhibe jodi apna khuchandi, are you saying that this is not assigned to the single bench?
Pass order.
How can I? Are lack of jurisdiction nahi jibo. If it is a division bench matter, it has to go to the division bench.
2 cases has been the honorable division bench has issued notice.
Tell seta apna sethi de memo ta dei thante na distinct pain.
Dei debe
Are sethi debe sir. Apna ei case ro sangare mention kari ki sethi mention memo dele list ho. The learned counsel for the petitioner seeks accommodation. The appearance likh dele. Mr. Bimbisar Das AGA. The learned counsel for the petitioner seeks accommodation. The matter stands adjourned. Liberty to mention for listing before the assigned bench. If the same matter, then you can mention before
Same
that division bench. Thank you, Mr. Das. Ms. Maharana, thanks for your time. Mr. Das, you can come for a minute. I have something to discuss.
Yeah.